During opening arguments, can I let the jury know that the doctor lied during his pretrial testimony? Would you like to know the answer? Come join me for a walk on the beach as I share with you this exact answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, I can. I can let the jury know that the doctor lied during his pretrial testimony. Now, you should know that opening arguments are an opportunity for me to go ahead and explain to the jury for the very first time what the specific facts of your case are, what the conflict is, what the issue is, what the doctor did to violate the basic standards of medical care causing you harm and injury. So now the question is, can I tell the jury about what happened during pretrial testimony during the discovery phase of your lawsuit? The answer is I can. But if I'm going to do that, I have to also explain to the jury what is a pretrial deposition. And that's fine. I can explain to them that this is pretrial testimony, questions that are asked and answered during the discovery phase of your lawsuit. So now, what does it mean to the jury if I now tell them during opening arguments, hey, listen, this doctor lied when I had a chance to question him about the events that occurred? Well, it gives them a sense that maybe the doctor is being less than truthful. Maybe the doctor is lying outright. There could be many reasons that the doctor will use to explain why he contradicted himself. But here's the one drawback and something that an attorney has to be very careful about when using that particular contradiction or a lie during pretrial testimony. The jury does not yet know what the true issues are yet. They don't know the evidence that we know, right? They haven't lived with this case for 2 or 3 years, which is how long it has taken us to get to trial. They haven't reviewed all the medical records. They have not spoken to any medical experts. So they are at a disadvantage and do not yet know everything that we know about your case. So to go ahead and start accusing the doctor of being a liar during opening arguments is actually pretty harsh, because most of these jurors trust their doctors, most of these jurors love their doctors, and now it's going to be somewhat confusing and they won't understand why we are so angry and hostile toward the doctor at this point, not knowing all the facts and all the details about why we believe your doctor was a liar. So, although it may be true that the doctor contradicted himself and that he lied, the question is that a good strategy to get the jury angry, to get them riled up, to get them emotionally involved in your particular case? Well, the answer is it might, and then again it might not. It depends on the facts. It depends what the contradiction is. If it's a small, minor contradiction, the jury will not get all excited and they won't get all bothered by this inconsistency. It's a different thing if the doctor said something significantly different, that there's a clear contradiction and it's a substantial one. In that instance, then maybe we can get the jury behind us to recognize, hey, this doctor is inconsistent, he was being untruthful. So what does that mean for his credibility? And if we can't believe what he has said about this one little issue, how can we believe what he's going to say or has said about other issues? And that's the whole point. During trial, we want to whittle away the witness's credibility, regardless of who it is, whether it's the person that you have sued, known as the defendant, or any other witness that is called upon to testify. Why do I share this great information with you? I share it with you because I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.